Motion, duly seconded is carried. Before anything, I'd like to acknowledge the presence of Representative Antonio Tino of the ACT Teachers Party List, and also Representative Juan Romulo of the Lone District of Pasig City. Will the committee secretary acknowledge our resource persons today?
Thank you, Mr. Chair. For today's hearing, we have the following resource persons. From Ateneo de Manila Law School, we have Attorney Harvey Bilang. From the Bangko Sentral ng Pilipinas, we have Attorney Joseph Matias, Attorney Andrew Asperin. From the Bureau of Corrections, we have Chief Superintendent Celso Bravo and Attorney Cesar Anthony Solis. From the Civil Service Commission, we have Attorney Hannah Kisha de la Serna. From the Court of Appeals, we have retired Justice Alfredo Ampuan. From the Department of Information, Communications and Technology, we have Mr. Giancarlo Christie. From the Department of Justice, we have the Deputy Regional Prosecutor Raul Prestoria, Regional Prosecutor Grimay June Elmido, Assistant Regional Prosecutor Marines Ledesma Ciudadano, Senior Assistant City Prosecutor Rudy B. Ricamora Jr.
Good morning, colleagues.
From the Intellectual Property Office of the Philippines, IPOPHIL, we have Attorney Louis Andrew Calvario. Morning, sir. From the Legal Education Board, we have Attorney Mark Benedict Sampaga and Ms. Danica Tantay. From the National Commission for Culture and Arts, we have Ms. Teresa Rayos del Sol and Attorney Agnes Isabel Garcia. From National Bureau of Investigation, we have Attorney Athena Florence Rativo. Morning. From the National Telecommunications Commission, we have Attorney Emerson Reina Jr. From the National Security Council, we have Attorney Isel Pang. From the Philippine Coast Guard, we have Lieutenant Commander Gilbert Alan Roelas. Morning, sir. From the Philippine National Police, we have Police Lieutenant Colonel Ruther Chris Parilla and Police Lieutenant Colonel Angelo Pueblos. From Public Attorney's Office, we have Attorney Maria Angela Hernandez and Attorney Noliver Barito. From the University of the Philippines Law Center, we have Attorney Neil Anthony Borja, Attorney Finessa Estigoy, and Professor Marvil Yasos. From the Integrated Bar of the Philippines, we have Attorney Paul Bongko. That would be all, Mr. Chair. Thank you.
Thank you, Comsec. Good morning to our distinguished colleagues, resource persons, and partners in this continuing effort to refine our criminal code. Last meeting, we generally refined provisions on counterfeit currencies and monetary instruments that close on Articles 166 to 170, particularly the treatment of guilty knowledge versus connivance as elements of qualifying circumstances, and the consolidation of related RPC provisions while preserving regulated penalties. We also reviewed Article 173 on the falsification of passports and travel documents, including alignment with Republic Act number 11983 or the Philippine Passport Act, potential coverage of foreign passports or visas to foreign jurisdiction, and the international obligations in the UN Conventions against transnational organized crime and migrants smuggling. Specifically, we agreed on the following: Articles 166 to 170 on counterfeit currencies and monetary instruments, the distinction between knowledge or guilty knowledge, connivance or active cooperation or conspiracy-like participation is a significant policy instrument for this study. The graduated penalty structure and framework of the existing revised penal code should provisionally guide the committee's approach. Attorney Finessa Estigoy of the UP Center was tasked prepare an alternative draft preserving the RPC's distinction between knowledge-only offenders and those acting in connivance, while integrating it into the new code structure. The DOJ and OSG were directed to continue refining the consolidated draft for Articles 166, 168, and 170, coordinate with the UP Law Center and Secretariat, and submit harmonized proposals explaining any departures from the RPC framework. BSP, POW, and other agencies were invited to provide additional inputs on economic impact, penalties, and due process implications. Article 173 and related Article 174 on falsification of passports and travel documents. The current draft needs substantial revision to align with the Republic Act number 1198-3. DFA was tasked prepare a revised draft harmonizing with the RA 1198-3 and to study the feasibility and policy implications of extending coverage to foreign passports and visas falsified within Philippine territory. The DFA, DOJ, RC, and UP Law Center were directed to collaborate on constitutional jurisdiction issues such as territoriality, sovereignty, double jeopardy, and international obligations, for example, UNTOC and the smuggling of migrant protocol. ESG and other transnational law enforcement inputs on operational realities were welcome for future deliberations. Deliberations on Article 173 and 174 were deferred pending submission of revised drafts and position papers. Thank you. Let's proceed. Okay. So first, let's go over the task list. Attorney Vanessa Estigoy was tasked to prepare an alternative draft preserving the obvious distinction between knowledge-only offenders and those acting in connivance while integrating it into the new code structure. Where do we stand on the submission?
Your Honor, I already submitted the task po online, which is currently being printed. But for the purpose of everyone, I can read the additional provision that I created po.
Okay, this is concerning Article.
This is for Section 2, counterfeiting coins, and Section 3, forging treasury or banknotes. In our
So what article?
Article 161, Article 166 and 167 of the Revised Penal Code, Your Honor.
But referring to the DOJ draft, that would be Article
Article 168, Your Honor.
160. So on forging treasury banknotes or other documents payable to bear importing and other such false or worse. Okay. 168 and end. So your paper relates to Article 168, you said? The DOJ draft or 166 of the revised penal code, right?
Yes, Your Honor.
Can you also back up so just to contextualize your position on the matter?
In our previous hearing, Your Honor, and for the committee's sake, we agreed to retain the provisions of 163, 164, 165, and 166 and 167. However, the committee was concerned on the absence of parallel provision of Article 165 under Section 3 because there's no article which penalizes uttering of forged instruments of credit without connivance.
Mhm.
So what we agreed or what the committee decided last meeting was to retain the RPC provisions since if we look at the UP law and the DOJ draft, there were no substantial revisions and to comprehend the situation wherein there's no connivance for uttering of forged instruments of credit, we decided to make a parallel provision under Section 3, similar to Article 165. So the additional provision would contemplate the utterance of false or forged treasury or banknotes obligations of securities or other instruments without connivance.
Okay. Is it possible to do members have a copy of the submission? Ito. Okay. So we have a copy. So that's your proposed wording. You proceed.
So to ensure consistency with the treatment of counterfeit coins under Article 165, my proposal introduces a counterpart provision for treasury or banknotes, obligations, securities, and other instruments. As suggested during the hearing, the proposed article will cover the knowing utterance of false or forged instruments without connivance. So under this proposal, it states article blank because it will follow after Article 167. Utterance of false or forged treasury or banknotes, obligations, securities, or other instruments without connivance. It states here, which is formulated with Article 165 in mind, any person who knowingly, although without the connivance mentioned in the preceding articles, utters any false or forged treasury or banknote, obligation, security, instrument payable to order, or other document of credit will suffer a penalty 1 degree lower than that prescribed in the preceding articles.
Okay. So this is modeled after 165 and meant to fill a gap that we noticed relating to the terms of false or forged treasury or banknotes, obligations, securities, and other instruments. No? So, are there any reactions to the proposed article? Any reaction, reaction, insights? BSP? May we hear from the BSP? Saan sila?
Good morning, Your Honor.
Yes, Spin.
Yes, Your Honor. Good morning. So I was still reading through the proposals, Your Honor. But on the proposed provision in the title itself, utterance of false or forged treasury or banknotes, obligation, securities, or other instruments without connivance. I believe, Your Honor, that with respect to forged treasury or banknotes, it is covered under Article 168 of the current uh, revised penal code, which is uh, titled illegal possession and use of false treasury or banknotes and banknotes. Legal possession and use of false treasury or banknotes, wherein the uh, provision pertains to those violated under the existing Article 166 of the revised penal code without connivance with the importers, manufacturers, or counterfeiters. But with respect to the gap that was discussed earlier, with respect to the obligation securities or other instruments, which is not covered by Article 166 and Article 168, it may be retained for those documents, Your Honor.
So just to clarify, Attorney Aspirin, she merely proposed to fill the gap, which is the article that was read. You have no objection.
As to the filling of the gap, Your Honor, I have
You
no
have to.
objection. But with the because it was titled the provision is titled utterance of false or forged treasury or banknotes. So it means it in the provision under 168 is covered by this
Treasury
proposed
false.
provision.
Is that maybe hear from Attorney Estigmay? If you comparing the two, Article 168, I do see false treasury and banknotes, which is also included in your proposal. So,
My apologies, Your Honor. I simply referred to Articles 166 and 167 with this. However, if Treasury and banknotes is already covered under Article 168, then I suggest we can just remove the Treasury or banknotes and retain the utterance of false or forged obligations, securities, or other instruments without connivance. Because as stated by the BSP, these are the specific instruments which are not covered by Article 168.
okay, as if we were to adopt the following the opinion of Attorney Aspirin, he would delete treasury and banknotes so that the proposed article would read utterance of false or forged obligations. Is that correct?
Yes.
Securities and other instruments without connivance.
Yes, Your Honor.
With that amendment, would that be satisfactory, Attorney Aspin?
Yes, Your Honor.
Okay. The other question is in Article 168 of the revised penal code says other instruments of credit. And then in your proposed article, Attorney Estigo, it says other instruments. Is there a possibility of an overlap there? Or is there an ambiguity?
Your Honor, in interpreting the proposed article, the what I was envisioning was that this would always refer to Article 166 and 167. So any instruments which are explicitly referred under these two preceding articles will be covered by this new article.
You're talking about you're talking about treasury or banknotes or pay. Well, 166 is versus treasury or banknotes, right? And documents payable to bearer. 167 refers to documents payable to bearer. So in your case, you're saying that it refers to that. Well, yours is obligations, securities, and other instruments. So if you look at the text of your proposed article, so we would revise it. Any person, and then those others, any fault. So any fault or forged, we delete treasury or banknote. So false or forged obligation, security instrument payable to order. That would be payable to order, right?
Yes, Your Honor.
Said that you yours refers to two previous articles, but those are like payable to bearer.
Yeah. Sorry, Your Honor, under Article 167, it states there other instrument payable to order or other document of credit not payable to bearer. So to for more clarity, I would propose to further amend so that we can explicitly state this specific instruments if that's all right with me as
So how would you, for the benefit of the ComSec,
so the amended provision would state any person who knowingly, although without the connivance mentioned in the preceding articles, utters any false or forged obligation, security, instrument payable to order, or other document of credit not payable to bearer, will suffer a penalty 1 degree lower than that prescribed in the preceding articles. So that it would perfectly encapsulate what was intended or under the preceding articles.
Attorney Aspin, can you respond to that? Does that fill the gap? Would you like the Attorney Stigoy to read it one more time?
Yes, Your Honor. Please, thank you.
Attorney Stigoy, one more time, please.
It would now state any person who knowingly, although without the connivance mentioned in the preceding other articles, utters any false or forged obligation, security, instrument payable to order, or other document of credit not payable to bearer, shall suffer a penalty 1 degree lower than that prescribed in the preceding articles.
BSP is amenable, Your Honor, with the revised, reworded provision.
Okay. Other responses? Well, Congressman,
Mr. Chair, para clear lang, can we, parang there's some confusion eh. Kasi sinabi ni, the proposal is for a new article, diba, under this subsection. And then BSP responded, rightly so, saying that Article 168 already covers if it is not, if there is no connivance. And then if you will read Article 168, use of any false or falsified refer to any section. Isayin natin yung instruments sa 166, 167, 166, 167, covered na ba lahat yun nung proposed? Kasi kung ganun, parang, what was this all about? At the end of the day, what was this all about?
So, attorney,
Baka hindi lang natin nakuha yung ano, baka there was some other instruction from the COMSEC or last time.
Attorney Stigoy, break it down. What is the gap here? What is the gap? And then how does your proposed revision fill the gap?
Um, Under section 2, Your Honors, we have because we section article 163, section 2 of the revised
So 163 is to the RPC or to the
PC, Your Honors.
okay.
If we will look at article 163 of the RPC and article 164 and article 165 of the RPC, we will notice that under article 163 and 164, there is an element of connivance. Then
This relates to
this relates to the false coins. And then in Article 165, we have a separate provision wherein there's no the element of connivance is absent. So there's no connivance that is being involved.
Let's talk about the
With respect
commodity.
with respect to the selling of false or mutilated coin.
Okay.
So we had a problem in our hearing previously wherein Article 166, forging treasury or banknotes or other documents under RPC, and Article 167, counterfeiting, importing, and uttering instruments payable to bearer. In those two articles, when we talk about the utterance of the false instruments, there is connivance. However, if we will look further, there's no article covering the utterance of false instruments without connivance. So I suggest
Knowing uttering, so knowingly uttering, how do you say that? Uttering it, knowing utterance of
doing utterance of false instruments
false
without
instruments.
connivance.
So there's no counterpart.
There's no counterpart
But for,
in Article 160.
other commodities mentioned, there's two. One is knowingly without connivance, and there's connivance.
Yes, Your
Is that what it is?
Yes, Your Honor.
So that for the commodities that you in your proposed article, meaning
For the instruments of credit.
obligations, securities, and other instruments, we should probably also amend the heading.
Yes, sir.
Let's see here, so it doesn't have a counterpart for knowingly without connivance.
Connivance. Yes, Your Honor. That's why I suggested, if I can remember correctly, we had a lengthy discussion regarding this. And then I suggested, why not we just go back to the RPC provisions since we have no problem with it. And there's no actually substantial revisions by both bills. We just go back to that, and to cover the case of knowingly without connivance, we can add a counterpart provision so that it can be consistent with the previous section.
Yes. Oo naman.
Mr. Sa akin, okay lang. Wala akong problema. It was just to clarify. But I was just picking up from the argument of MSP. It says, unless the act be any of those coming under the provisions of any of the preceding articles. So preceding article would be Article 167. 167 says, any person who shall forge, import, or utter in connivance. So reading that, in 168, so kung walang connivance, 168. Pero again, just to be clarified, just to make it express. Pero I think we should have read it that way before na unless the act be one of those coming under the provisions of the preceding provisions, articles, preceding articles, sabi na 168. Pag pumunta ko sa 167, may connivance. So dito, sa 168, pag walang connivance, except hindi siya expressly written. Is that the point? Is it fair? Para lang maliwanag. Kasi baka that's the only point. So there is really nothing to discuss anymore. Baka yun lang. Kailangan lang expressly para hindi na magka-confusion.
Reading the 168 as I read it, it's just knowingly. It's knowingly. So I would read this as knowingly without connivance. Am I reading it correctly? Attorney Asplin?
Yes, Your Honor, but following through with the observation of Congressman Romulo on the latter part of the article is the clause intended to use any of the false or falsified documents referred to in this section, referring to 166 and 167, shall suffer the penalty next lower in degree than that prescribed in said article. So article, so meaning uh 166 and 167.
So 166 refers to treasury and banknotes, no?
Notes and the
Payable to bearer.
and payable to bearer, Your Honor.
167 refers to
Instruments payable to bearer.
instruments payable to bearer.
So the element of connivance in 166 and 167 is if it is lacking, it is covered under 168.
168, correct.
Yes, sir.
But have we covered other types of instruments? I guess that's the question. Because that's the one I think Attorney Estego is trying to address, right? The gap with respect to other instruments. So we're not instruments payable to bearer, not not treasury or banknotes, correct? So that would be, as you proposed, obligations, securities, instruments payable to order, or other document of credit not payable to bearer, right? You're accounting for the other types of documents, and you're saying, hindi. 167 is
Payable to order, not payable to bearer.
Fair, di ba generic na yung other instruments of credit?
yun nga, this is the one I asked about. Other document of credit, but Attorney Estiga proposes other document of credit not payable to bearer.
Why make that distinction?
Because
I-limit mo.
to distinguish it from the previously identified documents. Kasi she had to point that out precisely to fill in the gap because the RPC is silent with respect to those documents. Tama ba, Attorney Stigoy?
Yes, Your Honor. However, if the BSP, Your Honor, can confirm if the terminology of instruments of credit can already encapsulate instruments payable to order or instruments not payable to
Yun ang
order.
ano.
Maybe it can be enough, and I would defer to the wisdom of the committee to just stick to the RPC provisions.
So in other words, what Attorney Stigoy is saying, asking for is a reality check. But this might be a distinction without a difference. We're talking about obligation security, instruments payable to order, and not payable to order. But is there, is that really different from the types of documents we identified in the earlier?
So my understanding here is other instruments of credit is very general.
Yes.
Oh, regardless of the owner to meron pala to others.
Attorney Esperin, can you weigh in the enumeration in the proposed article? The listed instruments. Okay. I guess do you confirm that these are different from the instruments previously mentioned? No, in front of you.
Yes, Your Honor. But apologies, Your Honor, we cannot definitively give an opinion with regard to other instruments of credit and commercial documents since our knowledge basically pertains only to currencies and banknotes. Our expertise pertains only to currencies, but as regards other commercial documents, I cannot give any definitive answer.
And then continue.
Mr. Chair, maybe we can ask the BSP to take a look at the enumeration, treasurer, banknote, obligation, security instrument, bring it back to the BSP, and then just in writing, advise the committee if all these credit instruments were covered by 16667.
Yun na lang.
Today.
Oo.
But
Ano na gawin natin?
Di ba?
We just want to confirm, we want to call apple and not oranges. Baka naman grapes, it might turn out they're all, the same. Kasi we're just going by the text to lawyers and lay people. Sometimes you look at it like, oh, it's different it's worded differently, or it's differently. It must be a different um, but actually it might be the same. Yun lang ang concern, di ba?
To clarify,
Continue.
parang the rationale for the proposed amendment is one to cover all other instruments
Not previously mentioned.
of credit. Not
Yes.
now the question is, hindi ba sufficient na yung all other instruments of credit?
And
It's meant to be the catch-all. Okay. The second rationale is to cover without connivance. Tama po ba?
hindi, kasi when you look at um, uh, ang ano dito, what articles 165 tama ba? 167 and 167 refers to certain types of instruments, right? 165 refers to sorry. 166, sorry. 166 refers to treasury or banknotes, documents payable to bearer. Okay, yan lang. Then 167 refers to instruments payable to bearer. Not payable. Mali pala yung ano, no? Mali yung heading. Not payable to bearer, right? So that would be payable to order. So ngayon, so when you look at 168 of the revised penal code, it merely refers to those types of documents, right? So in articles 166 and 167, it provides for um, two ways of there are two crimes contemplated. One is knowingly, right? Attorney Stigoy, knowingly. The other ones is into connivance, right? So what attorney Stigoy attempted to do was to what about the other types of instruments? Instruments not referenced in Article 166 and 167. Identify those as obligations, security, instruments payable to order, or other document of credit not payable to bearer. Right? Yun ang ginawa niya. And then, uh, we notice that while it provides for, the previous artists provide for connivance, it doesn't address knowingly only. So, to try to fill that gap. But I guess the other question, as pointed by Kong Roman, is that they really, do the documents, yeah, they might be worded differently, or they might bear a different name, but are they actually the same? Or do they even exist? Is there such a thing? So I think the question is really if it's I guess another way of asking it is it really worth making that distinction? Is that distinction actually grounded in reality? Tama ba? Parang ganun ang tingin ko eh. Is it grounded in reality? So babalikan tayo, di ba? Yes, with respect to the text, the way the designation of those instruments, they appear different. But is that really the case? Diba? Ganun ang gusto natin malaman. So the PSP will revert with a short lang yun, ha? Not more than one page yun,
Yes, Your Honor.
di ba? So we will have that before the next meeting. So with that, Congressman,
Fair para sure lang ha. So 168, everyone in this room reads it as kasama dyan yung without connivance. No one has a different opinion. Para lang sure tayo.
168.
168. 168 of the RPC
Yes.
covers without connivance. Okay tayong lahat doon. No one has a different view?
Yeah.
Okay na tayo doon. So the only issue to be resolved is for the DSPs to write this committee just to confirm kung covered na ang ng lahat ng instruments sa proposal ni Attorney Estigoy
Yes.
sa 166, 167, tama?
Yeah. So,
Yes.
yeah.
So probably, Mr. Chair,
168 already is covered by 168.
hindi, 168 says kasi preceding article, so
Yes, yes. Oh.
so 167 and 166,
So covered siya.
yes, 67. Baka nung time na yun, pahuli na to, pagod na tayong lahat. Yeah, let's move on to the next one. Baka
Oo.
pagod na tayo nun. That's why, ano na natin. Yung detalye
So-
too much.
We've stated it, question three ways, in three different ways. You just pick the best one that, you know, that resonates with you.
Yes, Your Honor, we will do, Your Honor.
Ano to? Yung article.
6.
Minerge yung tatlo. So, ano, babalik tayo dito?
Kasi
166.
sinabi
This is from the DOJ. Sino
OS.
Okay. Now, I have in hand, just hand it to me. Mainit-init pa. A submission from the DOJ and OSG concerning merger of Articles 166 and 168. Who can actually speak to this? Again, please contextualize because, I'm straining to remember deeply what this is all about. Solicitor?
Yes, Your
Sige.
Honor. Good morning, Your Honors. I was tasked, Your Honors, to merge 166, 168, and 170 of the proposal, and leaving behind other obligations and securities payable to bearer under Article 168. So, I do agree with Attorney Istigoy that under 166 and 168, there should be a qualifying circumstance of connivance to both. In our proposal, we did not include 170 because it's merely for possession and use, and it's not really germane to making forging and uttering. So we left behind 170. And the new 166 would only include matters that are within the jurisdiction of the central bank, and we left behind other obligations and securities under 168. Pero in both po, we used yung connivance. Then
Okay.
we also had a proposal doon po sa pinakababa, pinaghalo namin ho lahat ang 166, 168 including other securities and payable to bearer documents.
Okay. I will ask questions to guide myself. Okay.
Okay po.
So, you were initially asked to merge 166, 168,
And
and 178. 166 in the RPT relates to
Making, importing, and uttering false currencies.
forging. 166, diba?
166.
Forging treasury or banknotes, right?
Yes, sir.
Other payable to order, right? So 166. 168 refers to
Forging treasury banks or banknotes or other documents payable to bearer, importing and uttering such false forged notes and documents.
and 170 is
Illegal possession and use of false treasury or banknotes and other
why did I
instruments
mention
of
170? The 170, no? No, but you said earlier that you were tasked to combine 166, 168, and 170
proposal po. Opo.
of the proposal. Okay. Okay, nandito ako. Okay, hold on. 166 is currencies. Right? 168 is Notes. Then 170 is for
Legal possession and use of false treasury or banknotes and other instruments of credit.
now, okay, the next question is why were you asked to combine these three?
Uh, because of the term connivance when we were discussing regarding 16 because in the previous articles there is a term connivance. In 168 there is 166 there is connivance, but under 168 there is no connivance. And the same manner 170 there's also connivance. There's also no connivance. So we have to make it uniform. So we were because of that we were tasked to redraft or to merge them.
So in 166 is okay.
Mr. Chair, ulitin natin. 166, anong column? First, second, o third column?
Third, Your Honor.
166. Sa 166, sinasabi mo, yung making and importing and uttering false currencies. Ito yon. Is that correct? 166.
Yes, Your Honor.
Okay. You will intend to suffer. Ang sinasabi, bakit natin minix yung section 2 sa section 3? But anyway, doon na muna tayo. Sinasabi mo 166, walang connivance.
No connivance.
Sa 166 po, may connivance lang kasi sa proposal, the penalty,
Wala. There's none. Unless you are referring to 166.
Let's
That's why let's get
we have to
together.
we have
Are you
to be
referring to 166 or 163?
we have to be precise lang when you say connivance. Kasi when you look at 166 of the third column, it says knowingly to start, no?
yes sir, pero
But there's a paragraph later on, which is the last paragraph. It says
next higher in degree,
with connivance as a qualifying
yes,
sa penalty next higher degree sa second one. So may so there is a so you are actually addressing the qualifying circumstance of connivance.
yes sir.
Okay, so connivance is qualifying circumstance.
Mr. Chair, ang following. Yung una kong isa dito, section 2, ito counterfeiting coins. Minix natin sa mamayang konti sa 168, which is already section 3, iba na yan. Because really, I mean, there's a world of difference between coins and really documents. I mean, that's a world of difference. I mean, how can you counterfeit actually? I mean, again defies but section 2 yan, section 3 ngayon yung sinasabing without connivance. But even pwede. Oh, yung 166 sa third column may connivance, correct? You found that in the last
Last paragraph.
correct. Yung next is 168 in the third paragraph, is that correct?
Kaya ba? 168 last.
Diba 166, ano yung kinumbine mo? 166 of the third paragraph together with
168 po.
of the third paragraph. Ano yung title nun?
Sa 168 po, wala pong, actually, Your Honor, there's no third paragraph. There's only an enumeration. 1, 2, 3, and 4.
So in other words, you're saying the 168 that does not provide for connivance as a qualifying
It does
circumstance.
not.
Let's be precise. Let's be precise, okay? Tapos yung 170 about treasury and banknotes does not provide for connivance as a qualifying circumstance.
Yes.
So in other words, ang sinasabi mo, prosecutors, Solicitor Soto, tama, Solicitor Soto,
Yes, sir.
is that the base penalty is for knowingly, right?
Yes, sir.
Which is provided for in Article 166, 168, and 170. Am I right? Knowingly. May knowingly on.
Yes, sir.
Knowingly.
Yes, sir.
But only Article 166 provides for connivance
Yes.
as a qualifying circumstance.
Yes, sir.
And therefore, if 166 provides for connivance as a qualifying circumstance, then it should be a qualifying circumstance as well for Article 168 and 170. Is that what you're saying?
My first proposal, sir, is that 168 should also have a qualifying.
Okay.
My second proposal is that 170 should also have a qualifying if I am really forced to merge 166, 168, and 170. Pero medyo mahirap po kasi yung 170, so I just left it
Why?
as it is.
Why did you not include 170?
Sir, because to me, it only appears that one person possessing it and using it. It's not a person who is knowingly uh,
So you're saying from
importing and forging.
Di ba hindi na natin kailangan ito because we've settled the 166, 167, and 168, and we've asked Attorney Esperin to make sure that the documents are, I mean, you bring another point that should not anymore be discussed because it is honestly
Yeah, do you conclude with your forthcoming, position paper and the issue of murder?
I think it will not cover that issue, Your Honor. But if I may
Say,
give an input about the
the reason I'll just tell you why. Because when you look at this, Article 168 of the Revised Penal Code only refers to knowingly, no? And not to connivance. Actually, it only refers to knowingly, not to connivance. It doesn't. The problem is with Articles 168 and 170. Kasi in Articles 168 and 170, it does not provide for, that's only knowingly. Tama ba? It's only knowingly. 168 and 170.
68 ng
Sorry, of the DOJ draft. The third column. But let's hear from Attorney Estigoy.
Your Honor, just to, in support of Kong Romulo, just to jog the memory of the committee,
Hmm.
if I can remember correctly, the task given to Attorney Soto was way back June 16. And
Right.
then the task given to me was June 23. And in the previous hearing, we already agreed to retain the RPC provisions because we see no problem with it. And in
Oh.
addition to that, with the discussion of Kong Romulo that the situation of without connivance is actually covered by Article 168 of the RPC, then I think maybe just to jog the memory of the committee, that was the situation of why there was no task regarding this.
So this task was actually overtaken by events.
Yes, Your Honor.
I don't remember that. No, but Article 168, if you read Article 168 of the Vice Penal Code, it's only knowingly. It's only knowingly. So, knowingly lang. Pero yung connivance, wala pa rin.
kaya nga, exactly the point. Because under 167, may connivance. Yung naging issue, paano kung walang connivance? That is why, in fact, if we review what Attorney Estigoy first stated here, isa sa binigay niyang bago was to add the phrase without connivance. But as pointed out by Attorney Esperin, covered na ata yun ng 167.
So,
fair.
continue.
Actually, yung connivance dito sa mga provisions na ito isn't only in connection with forgers and importers, di ba? So if you in possession of and utter in connivance with forgers and importers, kaya dun sa 168 wala yun because this is just of the RPC, kasi this just has to do with illegal possession and use, false treasury or bank. Yung connivance in all of these is always in relation to importing, forging and importing, di ba? So yung connivance is not a general qualifier for all acts. If you connive with an importer
or counterfeiter.
or counterfeit forger. Oh, di ba ganon? Oh, kaya,
166,
oh,
it's
ayon sa
connivance with without qualify because you can connive with a counterfeiter importer. And in 168, treasury or banknotes can provide for
well,
you could connive with a counterfeiter to importer of false treasury or banknotes. But the problem is 168 does not say, does not even mention the word connivance.
Not covered. Those that are not covered by the fees. The free NSC attorney.
Oh, Professor Moore.
Uh, Good morning, Your Honor. Professor Borja from UPIGLR, also representing De La Salle University School of Law. I actually agree with Your Honors that perhaps when we interpret Article 168, it may not involve connivance anymore. First ground raised by Kong Tino, the very act of illegally possessing and using false instrument, uh, you may not need another person to do that. Comparing with importing, forging, uttering, most likely may possibility na may isa pang tao. So that's one ground which would say that without connivance is one element of 168. And the second one, which was aptly pointed out by Congressman Romulo, yung pinakaunang clause, unless the act be one of those coming under the provisions of any of the preceding articles. So parang sinasabi na yung pinag-uusapan doon sa mga articles may element of in connivance dito, hindi na rin kailangan. So it's a two-pronged ground that under Article 168 of the RPC may not need to be done in connivance. And as Your Honor said in previous hearings, maybe the term knowingly will do the job after all.
So the question, Professor Bohr, is for 168. Is there you could connive with counterfeiters and importers of forged treasury and banknotes, right?
then that
In 166 and 167 of the RPC, Your Honor,
No, I'm talking about 168 of the third column.
third column. Still connive, yes, Your Honor.
Yeah, but it
168
doesn't
of the
yes,
proposed bill.
of the proposed bill, but it doesn't provide for that. For connivance in 168 of the third column.
Only knowingly, Your Honor.
And yeah, so isn't that a gap?
I recall that we are trying to streamline everything, that if we're going to include the element of connivance, it's going to be an aggravating or qualifying aggravating circumstance.
And that's what Solicitor Soto tried to do. In his proposal, he was saying, okay, it's wanting to knowingly do the criminal act, but it's another thing. It brings it to another level. If you connive. That's what he's saying. Tama?
Yes.
So, continue.
Sure, di ba sa 168 meron namang connivance?
Wala.
168.
168 of the RPC.
With the 168 of the third column, merong importation and uttering in connivance with forgers or importers.
Kakalituhan yung RPC o third column.
Okay.
Okay.
So, sa 168 third column, meron yon.
Meron.
Okay. So, 168 RPC, wala, because this is not necessary, because this is covering merely possession and use.
Yes.
No? So, ang sinasabi dito, if you possess counterfeit instruments or whatever, mere possession is not a crime.
Yes.
Kailangan merong knowing
Knowing.
and the intent to use.
Yes.
Okay.
Yeah, I think
Pero hindi na,
we're not,
if your connivance is covered by the previous articles.
but only with respect to certain types of instruments.
Kaya nga, and other instruments of
That is
credit.
the assignment of Attorney Aspirin. Whether the distinction is actually grounded in reality, or if it's even worth making that distinction. Right?
Pero Chair, we disposed of the other issue of connivance na basically covered na yun ng iba articles, tapos itong 168 sa PC, hindi kailangan ng connivance.
Well, basically, if you look at the text, it looks like it's not covered. But that's why we wanted a reality check from Attorney Aspirin. Di ba? Nagre-reality check eh. Di ba? Kasi when you read the text of the law, it only provides for connivance as an aggravating circumstance in Article 166 of the third column, parentheses. When you go to 168, it talks about treasury and banknotes. It doesn't provide for connivance as a qualifying. 168 of the third column, not the RPC. Right?
Mr. Chair,
Yes.
so we keep ourselves to Section 3. Section 3 of RPC. 166, forging treasury. Yun lang, huwag na tayo tumingin sa second or third column. Just the first column. Nakalagay dyan, forging treasury or banknotes or other documents payable to bearer, importing. Meron dyan connivance.
Saan?
In connivance, on the third line on page 121, treasury, banknotes, certificates, other payable to enter importation at in connivance.
Yes.
Okay. Pag dumating tayo sa 167, again, of the revised penal code lang, huwag na tayo pumunta sa proposal. Any person forge, import, utter, in connivance. Ano na rin eh.
Where?
So, in 167,
Yes.
pagdating mo ng 168, it says, unless act be any of those coming under the provisions of any of the preceding articles. Kaya ako tinanong, is there anyone who has a different view that
Yun.
ang coverage dito is pag walang connivance? Everyone said naman, ang coverage nito kasama na yung pag walang connivance. So, wala na tayong issue doon. 166, 167, 168 of Section 3 was okay already.
Oh.
Ang naiiwan na lang is for Attorney Aspirin to eventually in writing advise the committee kung yung proposal ni Attorney Stigoy na mga instruments ay covered na ng 166.
Yes.
Yun na lang.
Yun lang.
Yeah.
That's, you know.
Attorney Aspirin.
Yes, Your Honor.
Okay.
So in other words, Chair, hindi na papalitan to.
Ah.
Okay. Ang posibleng dalawa kasi yung issue nga. The issue of connivance, na-settle na. Di ba?
Oo.
All cases are covered. Connivance and no connivance.
Yes.
Okay, so ang usapin na lang dito, are all the instruments covered?
Contemplated already by those,
Okay.
by articles, 3 articles.
Ito yung proposal dito ni
Attorney Stigoy.
No, the other one.
Soto.
Attorney Soto. Actually, may binanggit dito na sa ko nakita yun.
Parang overtaken na eh.
Tapos
No.
may binanggit dito na yung regarding obligation or security of the Philippines. This is under this one may propose na idagdag yung lottery, sweepstakes and other tickets printed by the government. So yun ang nakikita kong bago.
That's a new twist. Solicitor Soto, you weren't here. First, Attorney Stigoy. You were here in the last meeting. Solicitor Soto, you weren't here.
I wasn't there.
You weren't here. That's why it was overtaken. But Kong Tino raises another issue whether we should expand it to include ano yun? What's yung lottery?
As well as lottery, sweepstakes, and other tickets printed by government in connection with legal gaming activities.
Yes.
So I suppose this is motivated by some special laws.
Nasaan Kong Tino yung wording na yun? on the third page,
Second page of this
submission.
um
Saan yun?
before the paragraph before Article 168.
In definition.
Oh, obligation or security of the Philippines.
Okay. Ito in the definition of groups.
Yeah.
It says
Obligation or security of the Philippines.
these obligations to the Philippines shall mean all bonds, I guess bonds, certificates and indebtedness, national banknotes, fractional notes, coupons, treasury notes, Philippine notes, treasury notes, fractional notes, certificates of deposit, bills, checks, or drafts of money drawn by or upon authorized of the whatever, as well as sweepstakes tickets printed by government. Okay. This attorney Solicitor Soto, I'll ask him. Itong paragraph na 'to, definition of obligation security of the Philippines, where did you this is that this is you got this from Article 166, correct?
Yes, Your Honor.
For the most part, and you revised that particular paragraph from 168. In what way? Did you add how did you how is this different from the paragraph 166 in found in Article 166 of the Vice Penal Code?
Uh, under the revision, I made it for under 166, I made it uh under third paragraph, Your Honor.
Yeah. So how did you substantively revise this? You added the word as well as so on.
It already exists, Your Honor, doon sa proposal ng DOJ.
Okay, okay. I see. Ito. 121. Dito. Dito sa ito columns.
121.
Okay. So what we'll do, I guess, there's a we are waiting with bated breath for the position paper of aspirin, attorney aspirin, because when you look at it, effectively, what it is that the three articles mentioned, you have effectively the way I read it, connivance is qualifying because although it's element of the crime, right? In Article 168 of the Vice Code, it says if it's knowingly, it's a penalty. You impose a penalty next lower in degree, correct? Di ba ganun yun? So now it boils down to: are we talking about are these different, instruments, or they're the same? Or is it even worth making that distinction? But in the draft of submitted by the DOJ, it tried to uh, consider as standalone yung articles. They wanted standalone articles that says the base that imposes the base penalty for knowingly, and then connivance will qualify, will aggravate. Yan ang gusto ng ginagawa ng DOJ. But when you look at the RPC, it also does that, assuming there's no distinction in the documents. Because in the RPC, it says connivance, to commit a crime, you need to connive, right? And then to commit a crime, you need to connive. And then later on, it says, but if you don't connive, but you knowingly, you only use it, there's a knowing use of these house instruments, then it's the 30 next lower in degree. So effectively, it's also connivance is a qualifying circumstance, but it's a different, they approach it in a different way. Tama ba? Tama? Alam mo, may miss kong hindi pa nagsasalita ngayong umaga si Attorney Harvey eh. Mag, magparamdam ka naman. Do you agree?
Good morning, Your Honor. I was about to speak earlier, but on Congressman Tino's question, if I may, with that, on the question on where the lottery and sweepstakes portion came from, I had the same question in the previous hearing, in the June 16 hearing, and the response I got was it came from a special law, RA 1169, that says the tickets shall be printed by the government and shall be considered government securities for the purposes of penalizing forgery and alteration. So I think what the rationale behind that was to incorporate RA 1169 into the definition of the obligations of the Republic of the Philippines. But as to the other discussions, I agree with your position that um, everything is already covered by the revised penal code. So I also move for the retention of the old.
Assuming they're the same documents. But then, sir, Kung Tino will say, I'm reading your mind. Well, what about lottery? Diba?
Ako, okay lang kung isasama kasi may special law na nagsabi na government security sila.
Hmm.
Okay, but so, mukhang settled naman yata. No? Ako, ang nakita ko na lang na bago sa proposal, parang iniiba yung mga penalties. Tama? And I think, if I'm not mistaken, are they being lowered? Parang ganun yata. So, yun na lang.
So we don't always refer to the RPC.
We think if we are going to retain the RPC provisions, and then we're retaining the whatever penalties imposed by the RPC.
Well, I mean, when we say we're retaining the provisions, but I mean, that doesn't preclude us from lowering the penalties if there is another compelling argument to do so. Basically, ang sinasabi lang, huwag na natin baguhin yung pagbitilad-tilad ng RPC. Kasi kahit tayo nalilito eh. So, okay na yun. Pero kung gusto nating dagdagan yung coverage, is in the lottery thing, or if we want to adjust the penalties, pwede naman.
Would you like to
Pero yun nga, sa proposal kasi dito sa third column, yung just cursorily looking at it, mukhang pinibaba kasi meron dito may nakikita akong
ano yun? Nung vertical number.
temporal. Di ba mataas yun? May reclusion temporal dito eh. Hindi, meron din pala rito. Sorry. Yung number 3. Question Mayor. Kasi ito, Operation Mayor in its medium period. May ganon sa RPC. So meron some adjustments to the actually mas malinaw there's a table yeah. So yun lang which we may make the adjustments. Prison Mayor in its medium period as against Prison Mayor and the fine. Or is this just a typo or something? Kasi otherwise parang
Continue, anong page yan? At saka,
I'm looking at 168 third column, comparing it with the original RPC.
168 third column. Mr. Chair?
Baka hindi lang na-add yung yung kasi otherwise mukhang Prison Mayor
Yeah, Mr. Chair? Kung
inopia everything except number 2, number
Honorable Tino. Anyway, yung proposal is just to retain the first column. Yung original ng RPC to be double check lang kung covered na lahat ng instruments. I think even with respect to the penalties, hindi naman natin babaguhin na lang because these are crimes against public interest masyadong tatama sa ekonomiya. Kung there's a reason why it's called crimes against public interest. And just to add, so panitilan natin yung first column, just to double check. Pero yung tungkol dun sa mga lottery, sweepstakes, baka hindi rin dito yung proper place nun. Because meron naman RPC provision later on, Article 195, 196, which are against public morals naman. Kung kunin doon, di natin dagdagan kasi iba to Iba talaga to. These are issuances by the, instruments. But anyway, again, just to move forward, I think klaro na tayo. Let's just retain the first column. Let's retain the only thing that will probably change there if his attorney aspirant tells us later on na hindi kompleto. Di ba yun lang
yeah, it's worth distinguishing the documents. But you need the draft proposal from Attorney Estigo. You have a copy of that, right? Okay, as she revised. And also, the thing about the question whether or not we should include lottery, sweepstakes, or other tickets, must we do that? If there's a special law that already defines obligations and responsibilities of the Philippines, diba? Sayang naman yung ink kung sinama natin si Attorney Ciudadano.
Good morning, Your Honor. With regards to the inclusion of sweepstakes, I think if we check the commentary of Reyes, sweepstakes is actually an instrument payable to bearer. That's why I think it was just enumerated here. But even before, sweepstakes is included under Article 166 of the Revised Penal Code. Yes, Your Honor.
So that you're saying there's no need to actually mention it
Yes, Your Honor.
because it's already real assault and also a special statute assault.
Yes.
Right?
Sure, akala ko ba the special law is read by Attorney Harvey Viva? Says it's a security. Government security. Ng obligation of the Republic. And
Yes.
now,
Sama pa rin siya. Sama pa rin because hindi
payable to bearer daw
dito ko kasi ito dun sa article in the original text of the RPC, it defines obligation of security of the Philippines, what they include, no, what it means. So there was an enumeration, and so by according to Reyes, according to a statute, lottery and sweepstakes are included. So therefore, if Reyes says that and the special statute says that, there's no need to state it here. Para in the interest of lang just to be efficient, no? Yun ang, what Professor Borja would like to.
So with that, Your Honor, I move that we retain the RPC provision and subject to the position paper of our good colleague from the BSP. Your Honor.
But before that, Attorney Ciudadano would like to say something.
Your Honor, if I may be allowed lang po to make an additional comments on the term connivance.
Sure.
In Article 163, 164, and 166 and 167 of the revised penal code.
Right.
Because if we check the commentary also of Reyes, the connivance actually refers to uttering only, and it doesn't apply to importation and also the counterfeiters. Because if we make it an aggravating circumstance, there might we have overlap of different one act will be punishable by 3 different crimes. So it will fall here under, for example, in 166 of the revised penal code. If there is only uttering and there was no connivance, we can punish the crime under Article 166. We can also punish the crime under Article 168 because use is also uttering without connivance. And then we can also punish it under Article 172, the falsification and the use also of private documents. So I think, Your Honor, the connivance only refers to the word uttering. If we check the commentary of Reyes, the acts punishable, for example, under Article 163 is first the false or counterfeited coins. The second act is the offender imported the coins, and the third act is in case of uttering, he connived with the counterfeiters. So although if we read the paragraph linearly, strictly, the connivance applies to the 3. With this one, Your Honor, I think there's a disparity between imposing the same penalty for the utterer and the same as the counterfeiter and as well as the importer. So that's why meron additional element or qualifying yung uttering so that the penalty for all 3 is the same. But if there is no connivance in uttering, then it will fall under Article 168 of the OPC.
So you're batting for retention of the OPC?
No, Chair, no.
No.
Chair, ako, I have a
I'll continue and then we go back to Attorney.
appreciate that clarification. Kasi actually, nung binasa ko yung RPC, pagkakasulat niya, importation and uttering in connivance. So, parang, ako, intindi ko, ibig sabihin nito, you have to import and utter in connivance. Pero ngayon, inlaro ni attorney, nasabi ni Reyes ba, actually, connivance only relates to uttering, which makes sense.
Yeah.
Okay, so therefore, we cannot retain, for clarity, this is a problem with the Oxford comma, Mr. Shah. Bakit kasi importation, tama, then uttering in connivance. Tama po? Oh, see? So this is a problem with the lack of an Oxford comma.
But it wouldn't make sense if it's importation in connivance with the importer. You already,
Kaya nga, importation, tama.
yes, it would have been clear. But,
Oh.
it would have been clear, but
Dapat may comma, di ba, attorney? So what is the amendment that has to be made to the RPC?
that is a problem that Attorney should have pointed out. What is your proposed solution, Attorney Ciudadano?
Actually, no, Your Honor, we can just revise the provision and we can enumerate it like any person who shall commit any of the following acts shall suffer the penalty of or a fine not exceeding number 1 by counterfeiting, number 2 by importing false or counterfeited coins, number 3 by uttering in connivance with. I think that's clear, Your Honor, that it has the same intent as the original provision of the revised penal code, but it makes it clearer lang po that the connivance applies to uttering only and not to the other.
Hearing it, ha? Siyempre, tayo, there has to be some difference given to the status quo, right? Because the burden is on us to actually overturn it. Correct? So, notwithstanding the absence of the Oxford comma, if you read this, I'm looking at Article 166. It states in part, uh, on page 121, importation and uttering connivance with forgers or importers. Is there any doubt that um, that you cannot, if you know that importation cannot be done in connivance with importers? Diba? See,
If you're an importer, then what? It doesn't make sense to connive with importers.
yun nga sinasabi ko eh.
Okay.
So why would you because attorney Ciudadano is proposing to break it down. So why would you break it down if it's clear? Hmm. Hindi, sinasabi ko na nga, hindi ako I'm just saying, kasi there has to be some leaning in favor of status quo. And there's a compelling reason to change it.
Ito kasi,
Continue.
the importation, I mean, it's possible for an to import in connivance with a forger. Diba?
Ay,
So, kaya I bat for the insertion of an Oxford comma.
on Oxford, wala mo. Tingin ko pwede naman yun. But I think somebody wants
Pero if it's even clearer to enumerate or something, just to remove that ambiguity which necessitated the clarification by Reyes ba yun?
Yes.
Oo.
But Professor Borja, you were raising your hand.
Yes, Your Honor. Thank you. I'm in support of Attorney Ciudadano's proposal, but we're also amenable in whatever degree, whether we enumerate them or, as Kong Tino said, we just replace it with a comma. Because if we're going to include the element of connivance with the act of importing, it may somehow be an added burden on the part of the prosecutor. Because there's jurisprudence to say that it's not really related in this crime. It's related with dangerous drugs. An element of the act of importation is you only need to prove that something came from another country. You have to prove the point of origin. And it's only that you do not need to prove the chain of events on how such objects came into this country. And in this case, we have to prove in connivance. It's going to be an added burden. So that's all.
So why don't we do this? Let's wait for the paper from Attorney Aspirin, and then COMSEC put a sort of like a reminder there that whether we should um, break down the prohibited acts was proposed by Attorney Ciudadano. But since Attorney Ciudadano raised her hand, but it's in anticipation. Can you also submit the proposed wording? The one breaking down you. Yes.
From Article 166, Your Honor. of
Yes.
SPC.
Yes, the one you said it's clear if you break it down.
Okay, we will submit, Your Honor. Thank you.
Solicitor Soto.
Your Honor, just a question. So, going to make connivance an element for the three, uttering, importing, and forging? Or are we just going to make it as a qualifying? Kasi pag nilagay ho natin yung comma, magiging elemental na ho sa tingin ko doon sa tatlo. Pagka wala hong comma yon, elemental lang ho siya sa uttering.
Not really. Attorney continue.
Tanong ko sa mga lawyers, would it be clear if we just use importation, comma, or uttering in connivance with forgers or importers? Hindi ba yun yung intent? Or rather than tanong ko sa mga lawyers.
Ito yung wording ng RPC. No, the RPC says that. With a forger, sa third,
That's not
121.
the explanation earlier of attorney
Ciudadano. Because Attorney Ciudadano is saying, it's one thing to import, it's another thing to return. Tama ba?
kaya nga. So, or ganun.
Yung 60, I think it's 166, right? Because it's imperfectly and vaguely worded. Okay, Attorney Ciudadano, please explain your thoughts.
Your Honor, this applies also to Article 163, 164, 166, and 167 because of the word in connivance. So, but the
Ano ginawa natin sa 163? Did we adopt it? 163 was retained? You mentioned Attorney Ciudadano is the first articles. What again? Can you kindly repeat?
articles under the revised penal code, Your Honor.
One.
Article 163, Article 164, which is the mutilation of coins, Article 166, which is the forging of treasury or banknotes, and Article 167, which is the counterfeiting, importing, and uttering of instruments not payable to bearer,
So,
because it uses the word in uttering and then in connivance
Okay.
with the
okay. So 163 mix imports and others false claims, connivance with counterfeit and work importers, right? So there's a I think you call that continued dangling modifier. Tama ba ako? Parang dangling. Parang ganun eh. It's like a dangling modifier. So whether that would modify mix imports out and others. Pero there's also an internal sense. There's an internal sense in the text. Siyempre, if you're a counterfeiter, right? Or you're the maker of the false coin, right? You cannot connive with a counterfeiter. Or you cannot, if you're the importer, you cannot connive with the importer. Di ba? Merong konting, it,
Pero as I pointed out, an importer can connive with a
Yes.
forger.
an importer can connive with a forger.
Mr. Chair.
So,
Ah.
ako I propose na or
Or Professor Palarco.
Mr. Chair, I'll try to break this down into the basics of what is being punished actually here. You're looking at 4 acts. Number 1 is forging. Number 2 is importing. Number 3 is uttering. And number 4 is mere possession. So the way that the original provisions were concluded, if you forge, it has to be actually a perfect copy, because a forgery that looks ridiculously far from the original is not covered by these articles. So it has to be with the intent of deceiving the public, because as Congressman Romulo says, it's a crime against public interest. Now, if you utter, it means you're placing it into circulation. So the element or the act actually is heavier than mere possession. Mere possession, even if you knew that it was false, is not punishable, because maybe I have a false coin, I put it under my desk, my glass, to prove that it's a false note. So I possess that, but I don't have any intent to use it. If you take a look at 168, it says there knowingly possessing with the intent to use. So that possession itself is qualified by use, but from uttering, because it carries a heavier well implication, it has to be in connivance with somebody who imported it or somebody who forged it. So I think that's how it was rationalized before.
Continue.
so I propose to resolve this or to clarify the provision to remove the ambiguity of yung connivance. What does it apply to? It applies to uttering. So, to clarify, comma, or.
Comma or. Okay.
Ano, okay na ba? Mga prof, pasado ba?
Article 166, di ba?
Okay.
You're proposing that for Article 166.
For where in all provisions where the similar phrase applies, di ba? I think attorney Marit
Without any change.
enumerated, di ba? All the provisions where the same construction occurs.
Chair, pasensya na.
Yeah.
Siguro daming babalik ng grammar school talaga. End of the day, kung 166 lang ang pinag-uusapan natin, if you read 166, could we not read 166 simply as the forging or falsification of treasury or banknotes or certificates of other obligations and secured payable to bearer? Yun yung crime yun, di ba? That's an offense. Then, and, teka, 166 tayo, di ba? 166. Yan. Treasury banknotes, certificates, and securities payable to bearer, and that's banknote. Possess lang. Is that an offense? But still, isn't the fact of uttering the one that will show that you have intention? Kasi if you merely possess it, that's why you have to see, we never penalize what's in your mind. There must be an overt act. Kung walang overt act, walang kasi kung ang hirap yung sabihin eh. So dapat, review, import, what do we mean by import ba?
The import, you bring it into the country.
Yeah, so kunyari, nabili mo tong forged coin somewhere else. Assuming nabili mo somewhere else. So inuwi mo ngayon sa Pilipinas. Nakakukuha mo then uwi mo sa mo. Is that already automatically that already makes you an offender, a criminal under this or subject to a filing of a case?
I don't think so.
I don't think so. Because you have to prove that there's intent.
Yes, it's
And the proof of intent is in writing. Kasi kaya kailangan nabisahin together eh. Else, walang overt act. And kung walang overt act, of here, of course, specifically mentioned by the RPC.
Oh, may tanong.
Hindi masyadong
Well, to Professor Palarto. So if you import false or forged obligations or notes, that's not criminal.
you still have to prove the intent to be able to introduce them into the Philippines.
Under Article 166.
Yes.
Under Article 166. So import the false or forged obligations or notes. The way I read it, right? Di pa crime yun.
Because I don't think that this is a mala prohibita provision. It's mala in se, and intent has to be proven.
Oh, kaya nga. And you prove the intent here under Article 166 is if you connive. Tama. Look at Article 166 of the Revised Penal Code.
I think it's import and then utter.
The importation and uttering in connivance with forgers. Kasi you could read it as importation in connivance with forgers. Tama? Oh, yan.
Well,
Oo.
I think
you could read it together. Eh.
yes.
You could read that.
Importation and uttering.
Yes, because that is the
Oh.
offense na dun eh. And of course, subject to, to the experts here. No? Pero, kasi kung in the mind lang, ay, pwede mo sabihin,
Tama.
here, that it is your lucky charm.
He imported it. I wanted a false coin. That's nothing wrong with that.
Probably the volume of the amount imported will determine whether or not there was intent to violate the provisions of the law. If it's maybe one,
I imported because I wanted to give it away in a birthday party.
One coin,
Uh-huh. So
Okay, Chair. So ngayon ang intindi na natin is they should be understood together.
Together.
Unlike what was
Si Attorney Ciudadano was proposing to break it down.
Oo. Uh,
Si Prosecutor Cristorian.
Thank you, Mr. Chair. Just to add to the position of the Honorable Congressman Romulo, we have shared previously, Mr. Chair, as prosecutors, that is actually the challenge because mere possession of these kinds of instruments does not really merit the indictment of a person. Our challenge in prosecuting these types of offenses is really proving the intent to possess and the knowledge of the falsity. And as pointed out by Congressman Romulo, we can prove this by the overt act of circulating.
Uttering.
That is always uttering, Mr.
Okay,
Chair.
so let me ask. May I ask this for the committee. So importing false or forged publications of notes isn't it criminal? But
Next we make it criminal.
yun nga, tandi. That one, as presently worded.
I was referring to the possession, Mr. Chair,
Yeah, well, yeah, but
and not the importing.
no, yeah, I agree. Mere possession is not a crime. Yeah, there has to be an intent to use it or or you actually utter it.
And knowledge of the falsity.
Knowledge of the falsity. Correct. But the question is, mere importation of false or forged obligations or notes. Is that criminal? Yes or no? Under critical
yes.
mere importation,
Yes.
Under Article 166, paragraph 2, yes.
Yeah.
Oh.
paragraph. Oh, ano ba pinag-uusapan natin?
Hindi.
Can you read the relevant portion, please?
Importation of such false or forged obligations or notes.
After importation and uttering,
Oh. So, Article 166 reads, forging treasury or banknotes or other documents payable to bearer, semicolon, importing and uttering such false or forged notes and documents. The forging or falsification of treasury or banknotes or certificates or other obligations and securities payable to bearer, and the importation and uttering in connivance with foreigners or importers of such false or forged obligations or notes shall be punished as follows.
So, how many criminal acts how many prohibited acts are you counting there?
So 3 basically. For
Breakdown to element.
Oh, pinam zero yung sa mga sabi guys.
in importing and uttering payable to bearer.
so that is really important happening.
Merong
Problem.
Are you looking at, I see people reading Reyes.
Wala.
There are two reading Reyes.
May kamba eh.
So, Attorney Ciudadano.
Your Honor, I've checked my notes and also I double check it lang with Reyes if it's to be accurate. Under Article 166 of the Revised Penal Code, the acts penalized under that article is forging or falsification. Second is the importation itself of that forged or falsified treasury note or banknote. And the third is uttering with connivance with the importers for counterfeit.
So, there's three prohibited acts, not two.
Yes, Your Honor.
Well, so that bolsters the argument to continue.
Which is actually in the title of the article. Forging treasury or banknotes or other documents payable to bearer, semicolon, importing, comma, and uttering such false or forged notes and
So that
documents.
is reason to actually, that's reason in support of the proposal of continue to to first delete, after payable to bearer, delete and the importation, comma, or uttering in connivance. Tama ba kung Pino?
Well, if you agree, I mean, ano tingin nyo? Does that make it clear? If that's
That,
the intent,
that aligns with the, that aligns with
that is the intent.
or the reading of, Reyes. So that will require minimal change.
Also require changing the title as well. Kasi end dito eh. O, for to really drive home the point. Di ba? Na these are separate punishable acts.
Pwede rin. Si Attorney Harvey.
What is the point ba? Why are we discussing this?
Hindi kasi,
There's no need to change. Kahit na even assuming without admitting that there are three offenses, what is the purpose? Sabi nga ni Reyes, the second act is already criminal already. So why do you want that condition of in connivance? Is that the point?
hindi, parang hindi lang malinaw yung, yeah, so,
What you want to achieve? Dapat importation with connivance. Is that what you
no.
Wala nang problema. Then let's not touch it. Why do you want to touch it pa?
Attorney Harvey.
I was about to support also the argument of since we're reading the same provision, we have different interpretations. And also I'm reading it as importation and uttering.
Yeah.
Because if we're going by plain meaning rule, because this is fair notice to everybody that says the prohibited act, I'm reading it as for importation to be punishable, it has to be with utterance as well. The intention of the body is to be aligned with Reyes and say that importation per se is punishable. We have to clarify.
Okay.
Yes, Is there any other commentary saying something different? Or has everyone followed the Reyes formula? Kasi hindi naman siya based on the Supreme Court. This is a commentary by a respected jurist. But my point is, it doesn't necessarily mean that this is already cast in stone. So meron bang iba? Is there any other Supreme Court decision? Are we belaboring a point that never really happens? Hindi naman talaga nagkaka-crime na ganito. 2 oras natin pinag-usapan. Or is there any other commentary by any other respected jurist? Kasi hindi naman, just because Reyes said it doesn't mean it's the truth.
Then somebody do a kick case law. So then, madali lang yan eh. Just type in Article 166 Revised Penal Code, where the Supreme Court actually, lists the prohibited acts. Yun yun. Okay, sa Supreme Court case, meron yan siguro. Attorney Ciudadano also raises the other references to other articles that we already approved. Yung 163 ba yun? Pinaka natin. 163. Wala dito. Ito yun. Ito.
Yeah, we are adopting the Reyes interpretation of this provision. I mean, again, he's a respected lawyer, wala akong problema, but is that the policy to accept his interpretation of Article 166?
Is there somebody mag-case to lang? Look at the cases. Ano lang. If that is the view of Reyes, then we have to re-examine Article 163. Ah, because Article 163 is makes imports or utters false coins, comma, in connivance with counterfeiters, comma, or importers. What's the other article? Attorney Sinadano? Related current coins or in connivance with mutilators and importers.
Pero matapos na lang. Kasi 2 hours na tayo with the same provision. When we hear from everybody here, gusto nyo bang i-separate? Do you want to follow the Reyes interpretation? Or is the interpretation that they should be read the same? I think we have enough experts in this room
Yes.
ready to advise us.
Sino who is in favor of aligning this with the view of Reyes? Raise your hand.
1, 2. 1, 2, 1. Lang na concept. Concept. Naman tayo mo ng gusto.
Oh, align it. Harvey, did you raise your hand?
Oh, who does...
But
Let's
Sige, sige.
Who's finish first? Ilan yung for aligning with Reyes Comsec? 15. Ilan yung not no need to align with the Reyes and read it together. Please raise your
In other words, status quo.
status quo. One, Comsec pala. Ayan, meron pa doon.
Yung iba, dalawang beses po, nagtaas ang kamay,
Right hand. Hindi counted. Hindi lang.
So,
Fair. May I propose that the COMSEC put this on record so that when we discuss this in the mother committee and later on in the plenary, we can advise the lawmakers who will be voting on this that ito yung interpretation, ito yung boto ng experts natin for their consideration.
sige. So, park muna yan.
Park, but then with the votes.
Park with the votes 15, but Attorney Harvey wishes to reconsider his, no. But go ahead.
And the same article but a different aspect of it. Yung sa penalty lang, kung pwede lang pong balikan.
Penalty of 166?
Yes.
Yes. What
Yeah.
is the concern?
Because Congressman Tino brought this up earlier and I wanted to ride that wave, so to speak. The provision in the RPC and in the proposed version punishes it with reclusion temporal. So there's no other place other than this to reconsider this. Reclusion temporal, for reference, is the penalty that we impose for homicide. So if there's no question, this is not a trivial crime. It has widespread implications, yes. But are we really saying that forgery of money, importation of forged money is the same as killing somebody else? Maybe that merits a reconsideration. Yeah.
I may? This may relate to the comment. Actually, ako, mas yung importation as a separate punishable crime in itself, sa akin, makes sense thinking about it because we're talking about government, government currency or instruments. Di ba? So, obviously, yung pera o yung mga instruments have to be made here. So, pag in-import mo, ibig sabihin na hindi Pilipino yun. Di ba? Hindi gawa ng Republika. Okay. So, kaya importation pa lang, meron ng labag. Di ba? Okay. So, now, how does that relate to the comment? Well, I suppose the idea kung bakit napakataas nung penalty, as you said, similar to murder, is because it undermines the authority of the state with regard to currency and undermines the economy. Parang gano'n. Otherwise, baka bakain tayo ng mga pekeng currency.
No.
Oo.
Um, Your Honor, this is about public interest. We don't want to flood, no, financial market, economy with this um, fake securities, Your Honor. It's not only one person that is going to be killed, the entire economy. So I think reclusion temporal is just right. To send also the strong signal that we mean business here. In other countries, the penalties are even higher. Singapore, for example. So we must not be a dumping ground of forged securities, Your Honor.
Prosecutor Ricamora, and then Attorney Harvey, and then Attorney Asplin.
Yes, Your Honor. Just to react on Attorney Harvey's statement that the comparison between this crime and that of a homicide, for instance, any crime under public interest has direct effect to the economy. It has inflationary effect, and therefore it can be likened into debt, because that is killing me softly. Pataas ng presyo, unti-unti namamatay ang mga tao dahil walang pambili ng pagkain. That's why the imposition of penalty is just right, Your Honor. Thank you very much.
Attorney Harvey, and then Attorney Asplin.
Just to provide context with that comment, because again, the revised penal code it took us 100 years before we talked about this. So, what are the venue for us to talk about? Are we really punishing enough, or are we really over punishing? I'm just bringing that up. On a different point, we all agree or prisons are over congested. And one of the reasons why is we over punish. Nakahaba ng penalties natin dito. So that's why I keep bringing it up, because if we punish someone lang always 12 to 20 years, 12 to 20 years, may ipon talaga sila dyan. So yun dun gagaling yung comment. And then lastly, siguro wag po tayo mahulog sa deterrence rational. Lagi sinasabi, kakabaan natin yung penalty para ma-deter yung mga tao. Again, deterrence rational it's not really a proven point in criminal justice is an effective deterrent. No one's going to say, 20 years yung penalty, hindi ko na gagawin yan, pero kung 4 years na, ang gagawin ko na. No one's deterred to that. What's really deterring is certainty of punishment. Mahuhuli ba ito ginawa ko? At the penalties that we impose on a particular crime is usually dependent upon the value we impose. So if the second is this is so grave that it affects everybody, the scale merits reclusion temporal accepted. But if deterrence rational yung panggagalingan po natin, it's not really proven deterrent to deter others from doing crime. Yun lang po. Thanks.
See Attorney Asplin, and then Attorney Lassos.
Thank you, Your Honor. So I would just like to emphasize the gravity of the offense of counterfeiting currencies, especially it is recognized under it is recognized as an exemption under the territoriality principle of our penal laws, since it is specifically mentioned under Article 2, Number 2, as an exemption to the territoriality principle, which states should forge or counterfeit any coin or currency note of the Philippine Islands or obligations and securities issued by the government of the Philippines. So that emphasizes the gravity of the offense of counterfeiting currencies. And actually, now in our division, we talk about increasing the penalty for counterfeiting currencies. But as we have discussed, and the comments of our counterparts, we may agree with maintaining with the current set of penalties.
Attorney Lassos.
Kung hindi naman po deterrent pala yung penalty, yung dangerous drugs, bawasan na rin natin. Yung rape, bawasan na rin natin. Ang concern niya, law enforcement yun eh. And this is a legislative body. We are not legislating for law enforcement.
Ang gawin na lang natin ganito, no? Si Comsec. Where's Comsec? Bago. Si Attorney Aspirin.
Further, but if I may add about that, about deterrence. So in my experience with the office, as a member of the anti-counterfeiting division of the BSP for 15 years, of the 100, more than 150 cases that I have inventoried and monitored, about 2 or 3 of those cases, 150 cases, are repeat offenders. So maybe as in for that statistic alone, I can fairly say that it is a good deterrence in dissuading the commission of counterfeiting currencies.
Wala si Comsec. No, what we'll do is, with respect to that issue, we will park it first. Okay? Since we are considering whether first to align this with the views of Comsec. Comsec, hanap kita. So first we will park Article 166, pending be decided by the committee on whether to align Article 166 with the views of Reyes. No? Yes. That said, this may also affect Articles 160, I don't know, 163, 164, and 166 and 167. Okay, and then secondly, with respect to lowering the penalty, that's something that we can revisit later on at the committee. So, nasa tayo? Si Attorney Aspirin, baka namin yung law review article mo. Where do we? So we jump to 178, and for that we have. Sino?
So civil service
Okay.
for the merits and the medical certificate.
We are discussing Article 178 for the first time, no? First, was there previous discussion of this?
Yes. Yes. However, wala po kasi sina medical at saka yung civil service for the medical.
Okay. So we have approved this already?
Yes, although we approve it, pero comment po sila.
So we actually approve Article 178, subject to the insights of the Philippine Medical Association. Yeah, are you present? Yes. Would you care to comment on Article 178 of the proposed Article 178 on page 130?
Good afternoon, Your Honor. Attorney Bianca Nimfamundin from the Philippine Medical Association. A few comments for Article 178 of the third column, Your Honor. We noticed that there was a change in penalty first of originally in the original version of the RPC, the penalty was arresto mayor in its maximum to prison correctional in its minimum. In the current amendments, it has been reduced to arresto mayor only. So we were just concerned on why there is a difference between then and now.
Mhm.
When in the current state of course, digitalization and everything, it's easier to make the forgeries or the false medical certificates now than before during the time of the first edition of Reyes. So,
Therefore, it stands to reason that they should maintain the stiffer penalty.
yes, it of course it erodes public trust on the certificates being issued by physicians. So I think our opinion, our stand is to retain the original penalty from arresto mayor in its maximum to prison correctional in its minimum. The penalty of fine was already revised in the 2017, I think, updates of fines and penalties. So it's already the same.
So, aside from the penalty, what other views do you have? Comments?
Yes, Your Honor. Yes, Your Honor. And then in paragraph 1, there is a distinction there. Paragraph 1 of 178. Any physician or surgeon who, in connection with the practice of his profession, shall issue a false certificate. I believe, Your Honor, the use of the term physician or surgeon during, again, the previous version of the revised penal code, there was a distinction at that time. But in the present time, you cannot be a surgeon without being a physician if we're discussing medical certificates, unless we're discussing other types of non-medical doctors, non-medical surgeons.
Mhm. So, what if is there anything wrong with physician or surgeon?
It might cause confusion that there is a distinction between physician and surgeon. So
Okay.
our stand and our suggestion would be to just use the word physician. We can discuss the probably historically, because during the olden times, there was a distinction between physician and surgeon. Now, if we're talking about doctors, a physician surgeon is necessarily a physician.
Okay, any views? Well, that's okay. Analysis.
I just would like to support with respect to the penalty. Alam niyo po, sa mga PWD na mga kumukuha,
Yes.
maraming certificate na nakakalusot. So, nawawalan po ng dignidad yung PWD card. So, lagi nilang isa-second guess nung talagang PWD yung tao dahil sa proliferation ng false medical certificates.
Yeah.
Actually, Your Honor, kami, as physicians, hindi nga kami yung unang nakakakita ng false medical certificates eh. The first time, usually the front lines that would encounter it are those in the HR or those in the HR practitioners. Kasi sino ba ang nagpo-falsify? Mag-absent, sakit-sakitan leave. Yun. So, hindi kami yung unang nakakakita eh.
Okay. Does anyone see differently that we should lower the penalty? Is anyone of that view? If there being none, we should keep the original penalty. So we will keep the original penalty. That's number one. Does anyone feel differently about deleting or surgeon? Because according to Attorney Munding, tama po ba? Munding?
Yes, Your Honor.
Attorney Munding,
Mundin, Your Honor.
there's no point in distinguishing physicians and surgeons because surgeons are physicians. Oh, you were surgeon. There being none, we will adopt that proposal. So with those two changes, with respect to with respect to the medical aspect of this article, wala na tayong okay na, di ba? May we hear from the CSC?
Sir.
Attorney Serna on the balance of the article.
Good afternoon po, Your Honor, and to the honorable members of this subcommittee po. So the CSC's position po, we find nothing objectionable to the amendment of Section 5 of Article 174 of the RPC po. So we support this amendment po. So we thank the subcommittee for the opportunity given to the CSC to provide these comments po. So our final position paper po and specific comments po, we will submit the same po once the commission approves the position paper po and our principal signs the final position paper po.
But that position paper aligns with what you said.
Yes
That's
po,
not-
Your Honor.
Okay. So in that case, we are adopting Article 178 as revised. Moving on to Article 180. 180 na tayo. 179 was adopted. 180 is concerns art forgery. Art forgery. Yes. This is completely new. And may we hear from the IPOFIL? Can we have representative from the IPOFIL? Calvario.
Attorney Louis Calvario from Intellectual Property Office of the Philippines, which is the main agency mandated to protect and secure exclusive rights of artists and other gifted citizens other intellectual property. Now, IPOPL notes that the existing special law, that there is an existing uh, special law that punishes the crime of art forgery, and that is Republic Act 9105, or an act defining the crime of art forgery, providing penalties and institutionalizing the mechanism for art authentication, appropriating funds for and for other purposes. So otherwise known as the Art Forgery Act of 2001. So this law defines what constitutes art forgery and provides for the creation of an art authentication panel and specifies its functions, as well as the corresponding penalties imposed on any person who commits the enumerated acts of art forgery. Now, the proposed acts that constitute the crime of art forgery under the existing proposed bills, specifically 7206, are consistent with Art Section 3A of the Art Forgery Act, which defines the crime of art forgery. Now, it is the opinion of the IPO field that the crime of art forgery may be discussed in relation to various violations against intellectual property, specifically infringement, so whether of copyright, trademark, industrial design, and even unfair competition. However, there is a distinction, because usually what we protect in intellectual property are the rights of the intellectual property rights holders, like the right of disseminating the work, publicly performing it, or making it, in the case of trademarks, or using it in commerce. However, in art forgery, the ones which is really the target of protection here are the buyers themselves. So um, we should craft the law in such a way that there would be a distinction between infringement, the crime of infringement under the Intellectual Property Code, and the felony which we intend to include here in the revised penal code. Thank you, Your Honor.
But why should we make that distinction? I mean, a crime is a crime here. So how would your insight affect the post Article 180? Are you in favor of inserting Article 180 in the Code of Crimes?
In our submitted position paper, yes, we are
In favor.
favor of it. And but Your Honor, we also intend, because we're still planning to submit a supplemental position paper on this article,
Yeah.
and because there's continuing
Yeah.
internal discussion. So, but initially, yes, we are in favor of.
Because upon reading this, you confirm that it is a faithful reproduction of the
Yes, Your Honor,
prohibited acts from the
from the
statute.
special law, yes po, 9105.
How about with respect to the penalty? Is it also, did it adopt the
There
penalty
is a
imposed by
penalty in the
law?
special law, which is 50,000 to 500,000. But then in the proposed, it's also the same.
Yeah, I just
In
want to
Article
confirm.
180.
Okay. So, okay. Can maybe hear from Professor Mora.
Thank you, Your Honor. One thing I noticed is that it's a faithful reproduction of the Art Forgery Act, apart from the fine, which I would want to leave it to the discretion of our dear colleague, Attorney Calvario, whether it's proper to just impose a fine of not more than 500,000 pesos. Because in the special penal law, there is a minimum threshold. We have here not less than 50,000 pesos, but not more than 500,000 pesos. So if we just divert to just having not more than 500,000 pesos, would the committee be comfortable with that?
I am initially not comfortable with that because it's a special law. There was a there were deliberations done and that considered the penalty to be imposed, and we are overturning that. I mean, di ba? May special law na eh. Actually, even if we don't include it, that would still be operational. They could enforce a special law, right? So
Yeah.
if it's just a matter of integrating it, we do know we have an opportunity to actually amend the penalty, but I would proceed with caution before doing that because it was already deliberated upon by a special law. Yes, maybe hear from.
May I speak? I'm Tess Reyes del Sol from NCCA. Basically, the IPOFIL is what's telling us about the copyright and the trademark. Now, historically, the art market is now very vibrant, and the art market relied heavily on private transactions. So, we need to push laws to treat these high value art sales. So enforcing actually the fine art law is very difficult, and because the art market is highly secretive and proving that a seller knew a piece was a fake. So meaning po there is presumably criminal intent, and so the NCCA actually uh supports to retain Article 180 with amendments, but wanted to preserve RA 9105 as a complementary special law. Um, the National Commission on Culture and the Arts supports the state's continued criminalization of art forgery and recognizes the importance of protecting Filipino artists, collectors, galleries, museums, and the public from fraudulent acts involving works of fine art. Ultimately, criminalizing art forgery recognizes the authenticity is the foundation of the art market and cultural heritage. And a forged artwork does not merely deceive a buyer, it also corrupts provenance records, damages the reputation of artists and institutions, diminishes the value of legitimate works, and may result in a permanent loss or misidentification of important cultural property. A dedicated penal provision, therefore, fills a legislative gap by providing clear definitions, elements of the offense, and appropriate penalties tailored to the unique nature of art forgery. This is art forgery in the works of fine art, different from hypophil, which is trademark and um, copyright, right? So by doing this, we are protecting the artists and their estates. We protect also the collectors, the museums, the galleries, auction houses, and the public from fraudulent transactions involving counterfeit artworks. We also preserve the integrity of Philippine cultural heritage by preventing the circulation of fake cultural objects that distort historical and artistic records. We also promote confidence in the Philippine art market so that there will be we are encouraging ethical transactions and investment in Philippine art, and by doing this also we provide law enforcement and prosecutors with a clear legal basis for investigating and prosecuting art forgery without having to rely solely on general fraud provisions that may not fully capture the nature of the offense. And this also aligns with the Philippine law with international practice, as many jurisdictions recognize art forgery as a specialized offense because of its unique impact on cultural heritage, commerce, and public trust. And so we would like to we support the Article 180 with amendments.
What are the amendments that you propose?
Um, Number one is to define art forgery comprehensively because in the definition of the penal code, there's four, which is basically based on the signature with and usurpation. So we would like to define art forgery as an act of making, altering, copying, reproducing, attributing, signing, labeling, authenticating, or otherwise presenting any work of fine art as genuine, original, or created by particular artist, when such representation is false and made with intent to deceive, defraud, or cause unlawful gain or injury, whether the work is in physical, digital, electronic, or any other form. The definition of this in RA 9105 includes only the signature and the work. It can be expanded to add the definition of words attribution or labeling. The other one is authentication because issuing fake authentication paper is also a crime, I think, of any work when such representation is false and made with intent to deceive and such or cause unlawful gain or injury, whether the work is in physical, digital, electronic, or any other form.
Okay, so effectively you are revising RA 9105.
Yes po. Being the supplemental law, we also want to amend 9105. And the NCCA wanted to harmonize um, the following Act, RA 9105, RA 7356, RA 1066, and as amended by RA 11961.
Okay. Well, first, um, to the extent possible, we really just want to defer to the special statute. Say we don't want to rock the boat there. That's why my first question was, is Article 180, did it lift verbatim the prohibited acts to which Tony Calvario says
Yes.
it was, but you're not satisfied with that. You want more.
Because of the prevalence of digitalization already, we wanted to add,
Okay.
we wanted to expand the definition of art forgery there.
And RA 9105 defines art forgery, right?
Only the four the definition of art forgery here.
Meron po. Meron kasi it defines art forgery.
Yes, but only affixing or causing to appear a usurped signature of fine art, counterfeiting or imitating any original signature, selling or circulating any work of fine art being forged or usurped signature, another signature.
So if we keep the prohibited acts as listed here,
Yes.
the proposed Article 180, you would not have a problem keeping the enumeration here, provided that we broaden the definition of art forgery.
Yes, we can.
Tama po ba? No, we will keep the prohibited acts as worded here. But we will expand the definition.
Yeah.
Pwede po yan.
Yes po.
So, I was about to point out when I saw this that there has to be a section in the Code of Crimes on definition of terms. So maybe we can just amend the definition without touching the prohibited acts here. Do you agree that would be a reasonable approach?
We can also add po. We
Add
can
more.
expand.
Okay, but
Thing here is actually signature.
the signature could be physical, it could be digital.
Yes, but there are also other works like attribution of art, like for example, it's not only the signature.
Continue.
I mean, what's covered here, the definition is one, um, affixing a signature to a art.
Yes.
Okay. With the fake signature, of course, no? So, there's an intent to deceive because parang sinasabi mo, gawa ito ni Juan Luna.
Yes.
Something like that.
Yes.
Okay. So, hindi pa ba covered yung concern nyo?
Yung ano po kasi, yung meron po kasing mga gumagawa ng authentication papers na fake din. like doing the provenance, for example, of a certain artist, putting all the history, tapos hindi pala tama, hindi pala tunay. It's not also here.
So, okay. So, yung concern here is not no longer the reproduction or creation of a somehow falsely attributed work of art. Ito, ano na to eh, forging of documents, or
Yes.
falsification of documents.
Falsification.
Okay. Pero yung sa digital naman, hindi pa ba sapat po yung number 4, imitating or reproducing any work of fine art with intent to deceive the public? Ibig sabihin, very general naman yun na whether digital, whether painting, whether sculpture.
Yun nga po yung kasi po dun sa Special Law na 9105, it's not specified na kasama yung digital works. Kaya may
Okay. Kasi itong I interpret the fourth prohibited act broadly.
Mhm.
Imitating or producing any work of art with intent to deceive the public or the buyer as to the authenticity of the work. So how it's committed? We're not saying how it's done digitally, manually. We're not saying that. So that it means it could be done both ways.
Mhm.
So why do we need to specify it?
ang
The problem with specifying is that if you're so specific, we might omit others. People will say, but you didn't mention it. So it's not included.
we also wanted to define the work of fine art para mas tama po para mas complete.
And then Attorney Garcia, there's also an earlier provision. I think in book 1, no? In book 1 that says if you commit it digitally, then you will be meted the penalty 1 degree higher.
Mhm.
Pag yung sa cybercrime, in-integrate natin yung konsepto nun sa book 1 eh.
Nakasama na
Oo.
digital art. Okay.
If it's done through digital means,
Okay.
then it's a penalty 1 degree higher will be imposed.
Okay.
Yes.
So, ma'am, are you okay keeping the prohibited acts as worded since they are faithful reproduction of the relevant provision in Article 9105?
Ano po, sir? Actually, the NCCA wanted to support the retention of the prohibited acts, but recommends the following amendments. That number 1 is to define the work of art expansively. Also to remove lang po the ambiguity and also the art forgery po of art forgery definition.
And the definition of art forgery is separate and apart from the prohibited acts. In other words, the prohibited acts do not define what art forgery is. In the provision in RA 9105, there is a distinct definition for art forgery. Is that correct?
Yes, there is.
Separate and apart from the prohibited acts. Tama?
Yes po.
So, I go back to my earlier question. What if we keep the prohibited acts as listed here and that we simply broadly define, or we define more broadly art forgery? Would that work?
Losing an form with attempt to receive.
Mr. Chair?
Ang kulang pa rin po kasi it does not include authentication.
So you want to add you want to add prohibited acts in other words? Okay. Perhaps you can just submit
We can.
your proposal.
So yes, sir.
Spoon feeding po. I don't want commentary, so we should do this. Say it the way read it the way you want it to appear in the code of crime.
Al-
No?
Okay.
Prosecutor custodian.
Thank you, Mr. Chair. Mr. Chair, I would just like to point out that in Republic Act 9105, the Art Forgery Act, the work of art is um, discussed as including those art pieces that are produced in multiple formats. So that might include already those that are uh, produced by way of the digital media. That is all, Mr. Chair. Thank you.
Attorney Garcia, maybe we'll wait your, proposed Article 180. We just, just let's just be mindful about Article 9105 is a special statute.
Yes, yes.
It's preceded by like deliberations
Yes.
specifically on forgery.
Mhm.
So there is some weight and there's some difference there.
Yes.
So it's incumbent on you to actually show that, articulate a reason to actually revise it, not very hurry.
You just go on the point of whether to incorporate the special law here or not. If we incorporate it, there is the danger of, I think this was pointed out already in previous hearings, that we lose the context. For example, we look at the proposal now, we don't know what fine art is. It's not defined what fine art is. And it may be better to just actually retain the special law in itself, because the current proposal, what we're hearing is retain the no, include the prohibited acts here, but also the special law is still alive. Supplementary application daw yung RA 9105. That's very difficult in practice. Magkakalituhan yan. Yung supplementary application pa nga lang po ng revised penal code to special laws, nag-aaway-away na which parts of the revised penal code are supplementary to the special laws. If we do that here, same question arises. Which parts of RA 9105 will remain alive and which parts of them are supplementary to the proposed Article 180? So I guess we need to take a position po of, do we really incorporate the entire law or do we just make it standalone? Yun po.
Okay.
It's running.
Before,
Garcia.
supposed to be the Congressman De Venecia before was the one handling this. We wanted to change and actually strengthen the law 9105. Pero hindi kami natapos. So that's why we also have a draft of the of the draft 910 changes in 9105. So we wanted the 9105 to be enforceable because it has been a law since 2001, but we haven't it's not actually enforced.
Okay. So, but going back to what Attorney Harvey said, that is a sort of like a running debate whether we should incorporate special laws. If so, to what extent? And if we do so, we run the risk of actually not taking them out of context.
We also wanted
Because that's what, and that explains why I said earlier that if we are incorporating a special law, to the extent possible, it has to be faithful and predictable. Hindi hirap eh. And I appreciate the submission from the UP Law Center. This is a list of special penal laws incorporated in House Bill number, not in the proposed bills. And who's the Can you explain the nature of the document and what kinds of information you will find here?
Your Honor, the document we submitted is actually all of the special penal laws that we incorporated under HB 4074. To give everyone a background, when the UP Law Center Code of Crimes Committee was drafting HB 4074, one of their intention is to make comprehensive the Code of Crimes and include very important special penal laws because it is part of our mandate to align the existing laws with the progressive principles of law. So to make it easier for the committee to determine which special penal law they can add or remove, we specified all articles, including whether or not we substantially copied it or verbatimly copied the special penal law section for each article under HB 4074.
I see in your submission that you said it was you pointed out if it's verbatim or amended, but you did not say how it was amended.
Your Honor, my apologies. In some parts, it was substantially copied. The only difference was that with regards to the structure, but we did not we double check, it did not add anything or revise anything to the special penal law because
Substance, you mean?
yes,
The
by
format
substance.
maybe you format
Yes, Your
will
Honor.
change, but not the substance.
Yes, Your Honor. Similar to Prof. Harvey, the intention was only to incorporate them and not to amend them
Okay.
because the intention was some sections of the special penal law will still be in effect.
Yes.
Oo.
Continue.
Yeah, Chair, parang mas general principle nga siguro kasi isa sa mga objective ng exercise na ito ay sabi nyo, as much as possible or if possible to incorporate special laws into the Code of Crimes. Di ba? So, as Professor Harvey pointed out, pwedeng magkaroon ng mga problema dyan, especially if there conflict is created between these two texts, di ba? So, I generally agree. I mean, ang tanong ko, masasolve ba yun kung gusto talagang incorporate, kung basically, copy and paste lang yung relevant portions, yung prohibited acts dun sa special law, in which case, anong effect nun? Yung supplementary application mag-a-apply doon. Meaning to say, yung mga definition of the terms used, ang reference nun will be the special law. Ganun po ba ang epekto nun?
Very happy.
Without an explicit provision po saying in the Code of Crimes, for example, that RA 9105 would have supplementary application, technically there should be no reference. In judicial construction, you would say these are statutes in pari materia, yes. Pero technically speaking, wala. The context of this is only this. This is the prohibited act, and therefore everybody should know that this is what's prohibited by the law.
Okay, then, again, that's the basic question that has to be resolved. Kailangan pa ba talagang integrate lahat dito?
Ako, my feeling, I think if there is a risk of that the article will be interpreted out from because of for whatever reason, most probably because once the terms are not defined, well, I would just keep them out. In other words, we would just refer to the responsible. Kasi otherwise, gagawin natin dito, papasok natin to, kukunin natin, we'll look for all the, the terms that need to be defined. Right?
Yes.
And then we have to sift them from the special law, put them in here.
Kaya nga, Chair, that seems to suggest na dapat huwag na natin isama yung lahat ng mga special law.
No, well, I wouldn't generalize, but I think from what I'm hearing and what I sense with respect to RA 9105, that it is very, it's talagang merong unique definition eh. No definitions eh.
There has to be definitions, especially of the works of art, fine art. It's a different.
Tingin ko mas malinis yung ganun eh. Hindi naman natin, we did not decriminalize it by deleting it. By removing the proposal eh. That law is enforceable. Diba? Ang tingin dapat ganun na lang eh. Diba? Kung maraming definition of terms, kung may magumi tayo.
Sa may mga iba, Chair, na merong administrative as well as criminal penalties, mga ganon.
Di ba?
In other countries po kasi, they also have criminal laws on art forgery. For example, in France, like when they found out that the art is actually a fake, there is a they destroy it right away. And
It is criminalized by special by the statute.
yes.
Oh, criminalized naman pero hindi lang dito. May statute eh.
Apo.
So I my view is just delete Article 180. Is there any objection to that?
Delete na lang ba article amendments na lang? Yung ano natin? Or yung amendments na lang sa 0.3. Okay. So if we are going to delete Article 180, so what we're gonna do is just amend the RA 915. Okay. Okay.
Is targeted po yun.
Yes, okay po yun.
Mas targeted.
Okay. Let's target that.
Sino gusto mag-sponsor?
Yeah.
Have you filed the
We have a draft already, but we have not have we filed the 19 Congress. It was filed at the 19th Congress, pero hindi po siya natapos kasi.
Hindi nga po. Dapat ipa-file. It hasn't been filed in this Congress.
Okay.
Has it been filed in this Congress?
Not yet.
Not yet. Oh. So we will file it. Kami po ni Kong Romulo tsaka ni Kong Tinio. Para tatlo kami.
Sige.
Tatlo. Ha? Okay.
Sige pa.
So we will delete Article 180.
Okay. Sir, ikaw ang ilalagay namin file.
Kaming tatlo po para at least better than one.
Okay. Okay. Wala
More the better.
si Congressman De Venecia so
Oh, so to.
yeah.
Okay, so let's move on to Article.
Thank you very much.
Would you like to have a maybe 15-minute break? Would that help for quick ones? Okay, thank you.